Good afternoon and welcome to episode 2 of 39 Essex Chambers series of webinars where members of the Planning, Environmental and Property Group give what I hope will be concise consideration to 3 cases of importance in this field, with the intention of providing some insightful comment for practitioners. And this week we look at 3 challenges with a common transport infrastructure theme, with the intention of allocating 10 minutes or so to each case and concluding with a short Q&A session in which you can participate if you wish via the Zoom Q&A function. It is inevitable that we will not be able to address all the questions in the time available, but we may be able to provide written responses after the webinar has closed. On this occasion, I will consider the Court of Appeal's judgment in the challenge brought by Plan B Earth and others to the government's airports NPS, National Policy Statement. Philippa Jackson will then look at the challenge by Stop Stansted expansion to the Secretary of State's decision that Stansted's plans to increase its passenger throughput by 8 million PPA did not amount to an NSIP. And then Richard Wald QC will complete the trio by looking at Chris Packham's recent challenge to the government's decision to press ahead with HS2 following the EWCA review. We'll come to Philippa and Richard in due course. I'm going to start straight away with the Heathrow challenge, and I hope you've got, you should have the first of my slides on the screen in front of you. So, the Heathrow case. This is one of those cases in our field which from time to time makes it to the front pages of the national newspapers and features as a leading news item on the broadcast media. However, the headlines often fail to capture the substance of the Court of Appeal's judgment. I looked back over them preparing for today, seeing that The Guardian was saying Heathrow, 3rd runway ruled illegal over climate change, and The Independent was running Heathrow expansion blocked by the Court of Appeal. As we shall see, the effect of the judgment is rather more subtle, but less easy to distill into an attention-grabbing headline. So what did the claim, or I should say the claims, concern? The case in fact concerned a series of conjoined claims challenging the airport's national policy statement, which was designated by the Secretary of State for Transport under Section 5 of the Planning Act 2008. As most of you will know, the Planning Act 2008 was enacted to introduce a new procedure for consenting nationally significant infrastructure projects. And Section 5 gives the Secretary of State power to designate NPS, National Policy Statements, and these have been issued over the years to support the various categories of development covered by the Act, with the intention that they set a very clear policy direction and establish criteria against which individual infrastructure projects will be judged. And the airport's NPS provides in particular for the construction of a 3rd northwest runway at Heathrow, following on from the conclusions of the Airports Commission, that this was the best way to provide substantial new capacity in the southeast. The claimants for judicial review of the ANPS were many and various, and included Plan B Earth, Friends of the Earth, and a consortium of local authorities, the latter grouping, of course, being represented by Nigel Fleming, Catherine Dobson, and Stephanie David in these chambers. The Court of Appeal was hearing appeals from the decision of the Divisional Court, constituted of Lord Justice Hickenbottom and Mr. Justice Holgate, where the claims, the subject of the appeal, and a number of others were all dismissed. The claims before the Court of Appeal were grouped under 3 heads: the Habitats Directive claims and issues associated with them, the Strategic Environmental Assessment Directive claims and issues, and the climate change issues. The first 2 groups failed and the 3rd succeeded. And although the judgment runs at 285 paragraphs, the basis upon which the appeal succeeded is, in my view, in fact, quite narrow. Subsections 7 and 8 of Section 5 of the Planning Act 2008 require that the reasons for the policy set out in the National Policy Statement must be set out, and in particular must include an explanation of how the NPS takes account of government policy relating to the mitigation of and adaptation to climate change. On the facts before the court, the government conceded that it had expressly not had regard to and had not taken into account the Paris Agreement on Climate Change of December 2015 as part of the policy matrix which the subsection was intended to capture. The government did so on the basis of legal advice that it should not do so, which appears to have proceeded on two separate understandings. First, that the status of the Paris Agreement as an international agreement was not incorporated into domestic law, and the second, a seeming underlying concern that its terms, for those who don't have them immediately to mind, restricting the increase in the global average temperature to well below 2 degrees above pre-industrial levels, and to pursue efforts to limit the temperature increase to 1.5 degrees above pre-industrial levels, might be inconsistent with, and in particular more demanding than, the UK commitment under Section 1 of the Climate Change Act 2008 to reduce its greenhouse gas emissions at 2050 by 80% compared with their level at 1990. However, the court found that the government had taken an impermissibly narrow approach to its obligations under Section 5.8 of the Planning Act, had misdirected itself, failed to discharge its duties under the Act, and in consequence had designated the ANPS unlawfully, and the court so declared. The outcome was made simpler by the government's early concession that if the Court of Appeal upheld the claim in these terms, it would not seek to argue that Section 31 of the Senior Courts Act applied and that no relief should follow. It conceded that if it was wrong in relation to its treatment of the Paris Agreement, then it would need to revisit the ANPS. So that, in a nutshell, is what the judgment provided. And I turn just to offer three comments, which I hope will be of interest to practitioners. First, contrary perhaps to some of the surrounding press fluff, the judgment does not give the Paris Agreement the status of a trump card capable of defeating the most entrenched elements of government policy. In fact, the Court of Appeal's approach is simply, in my view at least, a textbook example of the application of conventional and well-established administrative law principles to some very specific, if perhaps rather surprising facts, namely the government's concession that it had expressly ruled out of consideration as irrelevant its support for the targets enshrined in the Paris Agreement, in a context where Parliament had enacted a specific duty in relation to NPS designation to take account of and explain the policy's relationship with the government policy in relation to climate change. The court was keen to emphasise that taking account of policy does not even require the executive to conform to those policy commitments, simply to take them into account and explain how it has done so. So in my view, there's nothing especially novel in the judgment, and practitioners do not now need to factor the Paris Agreement into every planning determination. Second comments. The government has now gone back to consider the effect of the Paris Agreement on the ANPS in accordance with the court's judgment. It seems to me that this must also require it to consider the implications of last year's amendment to Section 1 of the Climate Change Act 2008 to achieve net zero in the UK carbon account at 2050 when compared with 1990 emissions, i.e. the ratcheting up from the 80% reduction enshrined in the original legislation. It's perfectly permissible, however, for the government to come back with the same stated policy position, especially as aviation emissions are by no means the greatest contributors to greenhouse gas emissions, and evolving technology enables this contribution to be mitigated by the aviation industry. But we can be sure of one thing, that the assessment underpinning the new iteration of the ANPS will be subject to the greatest possible level of scrutiny, and that there will have to be complete clarity as to the government's discharge of its duties pursuant to Section 5, subsection 8 of the 2008 Act. Of course, the whole machinery of government is presently preoccupied with COVID-19, and perhaps the most interesting question is whether the inevitable hiatus will present an opportunity for the Prime Minister and other long-standing opponents of expansion at Heathrow to reassert themselves and deploy the requirement to revisit the climate change dimension of the ANPS as a reason for changing course. This would represent, of course, an extraordinary volte-face, but it cannot necessarily be discounted. My last comment is this. I put it in these terms: meanwhile, in another part of the forest, as our dear late lamented friend Andrew Gilbert, Justice Gilbert, used to frequently put it, how Heathrow Airport Limited and Aurora, who were the interested parties in the Court of Appeal, were last week granted permission by the Supreme Court to appeal against the part of the judgment upon which the claims succeeded, i.e. the climate change issue. No reasons for that decision were given, which is normal where permission is granted, but the fact that the Court of Appeal disagreed with a strong divisional court on this issue and the general public importance of the case would have been sufficient grounds for granting permission, in my view. No doubt this will be a great relief to the interested parties, who are now the appellants, who I am sure will prosecute the appeal with great energy. It seems to me that their arguments must focus upon discretion, and that they will be hampered by the absence of the government by their side, as the Secretary of State appears to have accepted the Court of Appeal's judgment and is or will be hard at work addressing the unlawfulness identified by the court, rather than pursuing an appeal in the Supreme Court. Of course, interested parties have successfully defended decisions on numerous occasions in the past where the decision maker has thrown in his hand, but this one will not be easy and will no doubt provoke a great deal of public interest and debate. And I should just conclude by remarking that no date has yet been set for hearing this appeal. So that concludes what I have to say on the Heathrow case. I'm going to hand over now to Philippa Jackson to address the Stansted challenge.
Thank you, Tom. As Tom mentioned, the second transport challenge which I'm going to discuss is the Stansted challenge, or Ross and Saunders on behalf of Stop Stansted Expansion against the Secretary of State for Transport. It's a case that all three of us are closely involved in. Richard is acting for the claimants, with Paul Stinchcombe QC, also of this chambers, and Tom and I are acting for Stansted Airport, which was the applicant for planning permission. Just to turn briefly then to the... Sorry, I'm just trying to turn the... Okay, one back. Thank you. There you go, the background. Just to turn briefly to the background then, in early 2018, Stansted Airport submitted a planning application to the local planning authority, Uttlesford District Council, seeking to achieve two changes to the current operation of the airport. It applied firstly for new operational development to construct new taxiway links and aircraft stands so as to increase the number of aircraft movements that could be accommodated by the airport's existing runway. It also applied to raise the planning cap on passenger throughput imposed by a condition attached to a permission granted in 2008 from 35 million to 43 million passengers per annum, an increase of 8 million passengers each year. And that increase in capacity was to be achieved partly through the improvements to infrastructure and partly through more efficient use of the existing number of flights. The claimants, acting on behalf of the campaign group Stop Stansted Expansion, wrote to the Secretary of State and asked him to treat the proposed development as a nationally significant infrastructure project, or NSIP, under Section 23 or Section 35 of the Planning Act 2008. And the effect of that, of course, would be to make the application subject to the development consent regime and to take it out of the hands of the local planning authority. And I'll come on the next slide to look at Section 23 and Section 35 of the 2008 Act briefly. But the Secretary of State declined Stop Stansted's request. He held that the application should be determined at a local level. And in short, his reasons for that were as follows. Firstly, he was satisfied on the forecast that had been provided to him by the airport that the anticipated increase in passenger throughput as a result of the new infrastructure would be significantly below the 10 million passengers per annum threshold, which would trigger the NSIP regime under Section 23. And in relation to his discretion under Section 35 of the Planning Act, he found that the impact of the scheme would be largely local and that the proposal was fully in line with the government's June 2018 policy on airports in the southeast of England making best use of their existing runway capacity, a policy I'll refer to as the Making Best Use policy. And that policy, which had not been challenged by the claimant at the time when it came into effect, emphasises that applications which do not qualify as an NSIP under Section 23 should ordinarily be determined at a local level by the local planning authority. That policy also considers, at a national level, the carbon emissions arising from airports in the southeast of England making best use of their existing runway infrastructure, including Stansted. So turning then briefly to the legislative framework which underpinned the challenge, two relevant provisions and two potential routes by which Stop Stansted Expansion's desired result might have been achieved. And the first of those was under Section 23(4) to 6 of the 2008 Act, which provides, in summary, that alteration works to an airport runway must be treated as an NSIP if they're expected to increase by at least 10 million per year the number of passengers for whom the airport is capable of providing air passenger transport services. And those words "is capable of" were at the heart of Stop Stansted's challenge under Section 23. The alternative route under Section 35 is a broad discretion whereby the Secretary of State may give a direction that a project which doesn't cross the 10 MPPA threshold and therefore qualify as an NSIP may nonetheless be treated as one for which development consent is required, where the Secretary of State thinks the project is of national significance, either by itself or when considered with one or other project in the same field. So that's the legislative framework. And in that context, Stop Stansted Expansion sought judicial review of the Secretary of State's decision on two main grounds. First of all, they argued that the Secretary of State had erred in his interpretation of Section 23 of the 2008 Act. They said that instead of forming a judgment about the likely increase in passenger throughput as a result of the works, the Secretary of State was required to identify the maximum theoretical number of additional passengers for whom the airport could technically provide air transport services once the new infrastructure was in place. That argument is perhaps best illustrated by an example. Part of Stop Stansted argument was that when considering how many aircraft movements the runway was capable of accommodating in any 24-hour period, and therefore how many passengers the airport could ultimately accommodate, the Secretary of State should have ignored the existence of night quotas, which mean that aircraft cannot lawfully land or take off from Stansted between the hours of 11 and 6 a.m. And it should have assumed that the runway would operate at maximum capacity across a 24-hour period, because it would technically be capable of doing so. The second ground of challenge was that Stansted argued that the Secretary of State had exercised his discretion under Section 35 unlawfully. They said that there was evidence before the Secretary of State that this scheme was in fact part of a larger scheme which would qualify as an NSIP. And those of you familiar with EIA challenges will recognise that argument as a salami slicing type argument. They also argued that there were errors in the carbon emissions modelling work underpinning the adopted Making Best Use policy, which the Secretary of State had relied upon in concluding that the carbon emissions from this scheme did not merit treating it as an NSIP. In formulating the Making Best Use policy, the Department for Transport had modelled the projected increase in carbon emissions if all airports in the southeast were to make best use of their existing capacity, and had found that this would not compromise the achievement of the Climate Change Commission's planning assumption for aviation emissions by 2050. Turning then to the judgment, the claim was heard by Mr. Justice Dove, and he dismissed the challenge on both grounds. In relation to the Section 23 challenge, he held that the correct approach was to ask what increase in capacity could realistically be achieved as a result of the works, and not what might arithmetically or technically, but not practicably, be possible. And as that exercise involved an evaluative prediction, there was no basis for interfering with the judgment made by the Secretary of State as to the expected increase in passenger numbers. In relation to the Section 35 challenge, he was satisfied that there was in fact no evidence that this scheme was part of a wider project which would cross the NSIP threshold, and that the carbon emissions challenge was an attempt to challenge the Making Best Use policy by the back door. He also accepted the explanation given by the Secretary of State in evidence, which rebutted the alleged discrepancies in that modelling work in any event. And just to complete the narrative, and before making a few comments on the judgment, shortly before Mr. Justice Dove handed down judgment dismissing the claim, Uttlesford District Council, which has been controlled by a party known as Residents for Uttlesford since the local council elections back in May 2019, refused the application for planning permission. And of course, the consequence of that decision is that any decision on the planning application will need to be taken at a local level. In terms of the wider significance of the case for planning, in my view, Mr. Justice Dove's judgment is unsurprising and is based on well-established legal principles. I would suggest that there are three useful points for practitioners to take away from the judgment. The first point is a narrow one, and the judgment confirms the correct approach to determining whether a project of this kind qualifies as an NSIP under Section 23 of the 2008 Act, and that's a question that hasn't been considered previously by the courts. More broadly, and secondly, Mr. Justice Dove reiterated and restated the line of authorities concerning the very wide margin of appreciation which will be afforded by the courts where judgments are based on technical or evaluative or scientific assessment. And in such challenges, as he said, a claimant faces a particularly daunting task to persuade the court to interfere with the exercise of that judgment. The same line of authorities was cited by the High Court in Plan B, and the High Court's observations in that context remain valid, notwithstanding the Court of Appeal's later decision. And I think that these authorities are becoming and will become ever more pertinent as we see an increase in challenges premised on climate change and net zero type arguments. And my third observation is that Mr. Justice Dove confirmed in the judgment that the lawfulness of the government's policy statement was now beyond challenge in these proceedings, and the court appears will be even less amenable to challenges to the technical assumptions underpinning an unchallenged government policy, when examining decisions taken in accordance with it. This kind of challenge to the lawfulness of a policy statement should therefore be brought directly and at the relevant time, as indeed it was in the Plan B case, which Tom discussed. And finally, just to note that an application for permission to appeal was refused by Mr. Justice Dove and is now pending determination by the Court of Appeal. So we wait to see, of course, what the Court of Appeal makes of these arguments in due course. Thank you. And I'm now going to turn and hand over to Richard for his part of the presentation.
Well, thank you very much, Philippa. Good afternoon, ladies and gentlemen. From airports to trains, my task is to present the third in what Tom has described as our trio of cases. It's the... Hold on, no. I'll have to reshare, excuse me. Trying to locate the correct presentation. If you forgive me for a moment. Struggling to find the correct slides. And there they are. Yes. Thank you. Apologies for that technical glitch. I'll have to move at a fair clip if we're going to meet our 39-minute promise. So let's move fast. Mr. Packham, the well-known TV presenter and nature photographer, sought to challenge the government's decision to proceed with HS2. At the same time, he sought an interim injunction to protect 6 ancient woodlands. This challenge came 9 years after public consultation into the HS2 scheme. And some 3 years after various judicial reviews and an environmental statement were published and the High Speed Rail London to West Midlands Act of 2017 was passed. In August, the government, through the Secretary of State for Transport, set up the EWCA review to conduct a cost-benefit analysis, essentially to determine whether the price tag, now sitting at more than £100 billion, was worth it. On the 2nd of February, that review recommended that HS2 proceed, and the Secretary of State so decided to proceed. Mr. Packham filed his claim 6.5 weeks later, and none of the parties raised any point on promptness. The court, however, did raise the point of its own volition, so promptitude was one of the issues that came before it. And the others were whether the decision was unlawful because of one of the following 4 grounds: a departure from the review's own terms of reference, a failure to recognise local environmental concerns, a failure to consider climate change issues. Any self-respecting environmental judicial review these days includes a climate change ground, and this claim was no exception to that. And finally, whether there was a legitimate expectation based on an unequivocal expression contained within the terms of reference. So the divisional court dismissed the claim as not prompt. It was filed 6.5 weeks after the decision under challenge. Unlike Tom and Philippa's cases, this was not a case that arose out of the 2008 Planning Act or any of the Planning Acts for that matter. It was therefore not a case where there was a strict 6-week time limit imposed. Nonetheless, the court of its own volition determined that there had been undue delay and noted in so finding that the claimant had not relied on new information. On the contrary, he had relied on information that had been in the public domain for some time, and noted also that to permit the application to proceed would place at risk a number of protected species. The review and the decision the divisional court found were limited in scope and were macro-political in nature and could only be impugned on Wednesbury grounds, therefore on very narrow or difficult grounds to establish. The terms of reference departure ground had no realistic prospect of success, the divisional court found, and so far as the environmental issues were concerned, the divisional court noted that those circumstances were unchanged since the 2017 Act, and that this was in effect an impermissible rerun of arguments that ought to have been run some several years ago. The climate change issues had been considered, including the Paris Agreement, which was part of that particular ground that was argued. And so far as the legitimate expectation ground was concerned, there had been no unequivocal representation, such as to form any basis for either a procedural or a substantive legitimate expectation. And then finally, the other part of Mr. Packham's application, the interim injunction, was refused, the divisional court finding that the claim had no real prospect of success, and in any event, the balance of convenience favoured the continuation of works. So which points arise out of the case that are or could be of interest more generally to planning practitioners, those that practice in the sphere of planning and environmental law? Firstly, this gives us quite a useful case study in the operation of remote hearings. This was an early example of one, having happened at the beginning of April. It worked well. Numerous journalists applied to attend and were able to do so. The divisional court appreciated clear submissions and the hard work of its judicial clerks and made specific mention of that, but criticised the excessive bundle containing a lot of unnecessary and prejudicial material and the excessive degree of disclosure requests that had been made. It is worth noting that part of that divisional cause was Mr. Justice Holgate, the other half being Lord Justice Coulson. And it's worth having a look, if you are to be involved in a remote hearing, at Mr. Justice Holgate's top tips for planning, which he penned just a few days after judgment was given in this case, no doubt having in mind some of the criticisms that he had made about the way in which the bundle had been prepared. Moving on to promptness, this I think is a rather interesting aspect of the judgment. I mentioned that this was not a case in which the 6-week strict time limit applied, but nonetheless, 6.5 weeks after the decision under challenge, a claim having been filed was found by the court to have been out of time. So the counsel of caution is that nowadays, even if you are dealing with a non-Planning Act JR, you need to do your very best to bring that claim, to file that claim within 6 weeks, unless there are pretty good reasons for a delay. We also take away from this case, I think, some interesting points about the limits of judicial review. The claimant's argument was that the review, the EWCA review, was effectively a blank piece of paper. That got nowhere. The planning court, like the administrative court more generally, is very alive, or to use the current favoured word, very alert to veiled attempts to rerun unsuccessful arguments under cover of a challenge to a more recent decision. In this case, those arguments could have been run several years ago. Many of them, or most of them, had been run that amount of time ago. What else comes out of the case? Well, 2 or 3 things, I think. Climate change, I mentioned this, like many environmental judicial reviews, included a climate change challenge. That didn't work, principally because the EWCA review had specifically been asked to consider the scope for carbon reductions in line with net zero commitments. The case that Tom has addressed us on, the Heathrow challenge, predates the net zero commitments. But here, and the Divisional Court was at pains to make this point, there was specific reference made to the net zero commitments. There was a finding that there was, albeit a fine balance, a balance found in favour of the advantages of the scheme over its disadvantages, provided that phase 2 savings were made. And this issue is one that is likely to continue to arise, whether it must do so by virtue of a statutory duty, such as under the 2008 Act, or in other cases also. So it is something to watch out for. That's not to say, and this is probably a good example of it, that all attempts to raise climate change as a ground of challenge will succeed. But it is one that I think is going to be increasingly prevalent in environmental judicial reviews. Then last couple of points, interim relief. The Divisional Court went back to the case law, medical justice case. It's a comparative rarity in environmental judicial reviews, but it found that there was no real prospect of success. And in order to do so, it had to consider the underlying merits of the claim. The hearing was originally listed just to consider the interim relief application, but because, as will almost always be the case, in order to answer that question, it is necessary first to determine what the strength of the grounds may be. Both aspects of the claim were heard together. Finally, Mr. Packham has decided to appeal. I understand that an appeal has been filed. That appeal is based, amongst other matters, on a failure to consider the Paris Agreement. So, in a sense, it is an attempt to deploy the narrow basis upon which the Heathrow litigation thus far has succeeded in this different context. It may well be that because of an awareness of the increased tendency to invoke that particular argument elsewhere, the Divisional Court was at great pains to distinguish the facts of this case, the Packham case, from those of Plan B. Now, finally, it's a little bit of a cheat, and we've got a few minutes left, but I've included a brief reference to another HS2 challenge. It's very recent. It was only a fortnight ago that Miss Granger Taylor, who is a resident in the Euston area on the HS2 planned route, received planning permission from Mrs. Justice Lang in her claim or her challenge to the design around Euston Station, including based on human rights grounds. That claim, I think, interestingly, relies on an engineer's report on structural integrity of the 3-tunnel design between Park Village East, where the claimant lives. It means, permission having now been granted, that the planning court will have to consider competing safety evidence in order to determine the proportionality of any risk inherent in the design. And that is necessary because of the human rights arguments. Both a threat to life and property have been invoked as part of the claim. So the planning court will not be able to shy away, as it often wishes to, from grappling with rather technical, rather difficult, rather complex evidential issues that arise where competing parties advance different engineering evidence to establish or combat the contention that the design in its current form will cause damage. So I leave that as one to watch, and I hand back with the few moments that remain to our chair, Tom, I gather that there have been some questions incoming, and we now have an opportunity to discuss those.
Thank you very much, Richard. Yes, as you rightly observe, we're up against our 39-minute timeline. Indeed, we have already passed it by my reckoning, but very briefly, I think we'll just air a point each in terms of the questions that have been received. I think it would be sensible to keep going with the Packham theme and the issues that you have just covered. And the point that I'd like you to deal with head on, as it were, in terms of practitioners looking at time limits for the making of applications for judicial review in conventional judicial review terms, not here looking at the statutory 6-week time limit. What is your view on how practitioners should now treat the longer period that is in theory available in relation to planning judicial review claims?
Well, I think my view is that it's inevitable now that the 6 weeks time limit that apply under many planning challenges are having their own impact on the way in which courts view the issue of promptness in other forms of challenge. Of course, for many years there have been some 6-week challenge periods, and the court was, bearing in mind that the court raised this point of its own volition, it then cited the Finn-Kelsey judgment back in 2008, the Court of Appeal judgment, and extracted from that a particular point, which was within that judgment is a reliance on a 6-week statutory period for some forms of planning challenges in those days as a basis upon which to regard, in that case, a little shy of 3 months as being insufficiently prompt. But I suspect, and I detect in the cases that I've looked at, that there is a creeping shortening of the notion of promptness, and in any event within 3 months, because of the prevalence within the planning context of 6 weeks periods imposed by statute.
Thank you very much, Richard. Philippa, in relation to the Stansted case, you referred to the making best use policy, the government's policy in regard to making best use of existing runway capacity, and the court's finding that the Secretary of State had been entitled to rely upon it. Does it make any difference in this litigation, the Stansted litigation, that the Court of Appeal has declared the ANPS to be unlawful?
Yes, interestingly, in fact, that is a question which Mr. Justice Dove actually addressed in his decision refusing permission to appeal, which he did hand down reasons in writing in relation to, but I don't believe they're publicly available. And he dismissed that argument, which was raised after the judgment was handed down and after the Plan B Court of Appeal decision was handed down. He dismissed that argument really for the reasons that I discussed in my presentation, namely that unlike in Plan B, the MBU, making best use policy, had never been subject to legal challenge, and therefore the decision maker was entitled to rely on adopted and unchallenged policy. So he felt that there was a fundamental distinction between the two cases. So as matters stand, that is the position. Clearly, we'll wait to see what the Court of Appeal makes of it all, as I said.
Excellent. Thank you very much. Well, I noticed we are now somewhere over 3/4 of an hour, and I think we ought to call things to a close there. Thank you very much to all those who have participated by following the 3 presentations, and we hope you'll be back for more when episode 3 comes along. Thank you very much.
Thank you.
Thank you.